Welcome back to Introduction to Talmudic Legal Logic. In this lecturette, we'll talk about broad and narrow readings. A perennial problem in constitutional and statutory interpretation is whether to read a statute or a constitutional clause in a broad way or in a narrow way. There are many cases in which we have to figure out whether a particular rule should be read in an expansive way or in a constricted one. For example, if a statute provides a list, how do we know whether the list is closed or open? Meaning, how do we know whether the law only applies to the circumstances enumerated in the list or in circumstances beyond the list? Also, is an example in a statute something that proves the rule or limits the rule to the example? The Talmud attributes two different interpretive approaches to Rabbi Akiva and Rabbi Ishmael, respectively. Rabbi Ishmael uses a narrow reading of the text. He prefers reading biblical laws as applying only to the specified situation. This method is known as generalization and specificity, klal ufrat. Rabbi Akiva, in turn, prefers reading biblical laws broadly, as applying to a large number of cases, and his method is called amplification and restriction, ribui umiut. Let's start with amplification and restriction, Rabbi Akiva's approach. Amplification and restriction implies that the default rule is the broader one. Usually, if an individual example comes along a general rule, it means that the general rule applies with a small exception. Generalization and specificity, Rabbi Ishmael's approach, imply that a particular detail in proximity to a general rule is there to explain the rule, to illuminate what the rule applies to. Most Talmudic disputes about how to read a particular biblical or Mishnaic statement involve one of the following scenarios. There might be a broad statement that is followed by a narrow statement. There might be a narrow statement followed by a broad statement. There could be a sandwich, a broad statement followed by a narrow statement, followed by a broad statement. Let's discuss each of these in turn and use some examples. Broad statement followed by narrow statement. In Exodus 21:25, the biblical law of retribution is listed. This is the eye for an eye punishment principle. And this particular verse reads, burn for burn, wound for wound, bruise for bruise. Kviya tachat kviya, petza tachat petza, chabura tachat chabura. In Talmudic sources, this principle is the basis for tort payments, which is to say, the sages interpret this not as referring to actually maiming the other person, but rather as receiving appropriate monetary compensation for the injury. But this raises the question, are you liable to pay for any burn, kviya, that you've caused, or only for burns that resulted in wounds or bruises? Rabbi Ishmael interprets this in a narrow way, saying that the specific mention of a wound or a bruise is there to explain that the liability arises only for burns that cause wounds or bruises. Rabbi Akiva interprets the statement broadly. Any burn, including those who did not cause a wound or a bruise, should be compensated. Let's take a look at an example of a narrow statement followed by a broad statement. In Exodus 22:9, we find the rule regarding a situation in which B gives A, quote, an ass, an ox, a sheep, or any other animal to guard. And while under A's care, the animal dies, is injured, or is taken, and there's no evidence as to what happens. Ki iten ish el re'eu, chamor, ass, o shor, ox, o se, a sheep, o v'chol behema, or any other animal to guard. The Talmudic question is, does this rule apply to asses, oxen, sheep, or to any animals? In this unique case, both approaches agree. When the broad statement appears at the end, the rule is to be read broadly according to both Rabbi Akiva and Rabbi Ishmael. Now let's take a look at a situation where we have a broad statement followed by a narrow statement followed by a broad statement. According to Rabbi Ishmael's approach, usually the detail in the narrow statement explains the reach of the broad statement. And according to Rabbi Akiva, because the broad statement brackets the narrow one, the narrow statement is to be seen as merely an exception to the broad rule. Let's take a look at an example. Deuteronomy 11:9 involves kosher rules and allows people to eat of anything in water, all that has fins and scales, in the water, the seas, and the streams. Should you eat anything in the water, or just what's in the seas and in the streams? This is a trick question. This actually requires a broad interpretation because the order here is actually different. There are two general statements here in the water, followed by a narrow statement. So is this about the test that's being applied or about the outcome? Let's take an example from modern US constitutional law. Those of you familiar with US constitutional law know that there are three levels of scrutiny which guide the balancing between governmental interests and individual rights. We call them strict scrutiny, intermediate scrutiny, and rational basis. Almost always, a strict scrutiny test will lead to the individual prevailing, whereas a rational basis test will lead to the government prevailing. Here, too, it's possible that the Akiva school, which is guided by broad interpretation, uses the test that gets them there, whereas the Ishmael perspective, which is guided by narrow interpretation, adopted the legal framing that gets them there. And this tells you something about the more general approaches that these two sages have as to how to perceive and approach the biblical text. Rabbi Ishmael's generalization and detail method assumes that the Torah speaks the way that humans speak to each other, and he's only willing to expand the verse beyond its pshat, beyond the way that it reads on its face, only if it stems from the verse's plain meaning. By contrast, Rabbi Akiva's more expansive approach looks carefully at any part of the verse, including even the smallest letter, and is willing to learn halachot, rules, from such minute exegesis.